Hello and welcome. I'm Kelly Weiss. I'm the Executive Director of Marketing and Communications here at the School of Law. Thank you everyone for joining us. We're going to have a great discussion today around the impeachment trial that is underway. Before we get started, I just wanted to give a few house rules. You will be on mute throughout the presentation, and if you can have your video off, that helps as well for the streaming and for the Zoom platform. Once Dean Amar has gone through his talk, we will open up for questions. And how we'll be doing the questions, if you haven't joined our previous virtual events, you will put your question in the chat and I will be monitoring the chat, and then we'll ask Dean Amar questions so that he can answer them. So I will hand it over to Dean Johnson now.
Well, thanks very much. And thank you all for being here today. We have a true pleasure. We're very fortunate to have Dean Vic Amar from the University of Illinois College of Law, who will be talking with us about impeachment in the second impeachment of President Trump and the proceedings that are going on as we speak. Dean Amar is a longtime friend of UC Davis School of Law. He served on the faculty here for a number of years. Before going off and becoming dean at the University of Illinois. He was also, and I was very lucky to have him serve as the associate dean, the senior associate dean for academic affairs for 8 years. He's been at the University of Illinois since 2015. He is a well-known, influential constitutional law scholar who's often featured on CNN, in the New York Times, many other media outlets. He clerked for the Judge William Norris of the U.S. Court of Appeals for the Ninth Circuit before he clerked for Justice Harry Blackmun with the U.S. Supreme Court. He's a graduate of Yale Law School, and he was an undergraduate student at UC Berkeley. And his most significant, in my mind, achievement was he played football for the University of California football team. So we're very lucky today to hear from Dean Vic Amar talk about Impeachment Examined.
Thank you so much, Kevin. It's so good to see you and to be with all my friends at Davis. I will offer a little disclaimer. Kevin is very generous in everything he said. Play is a very active verb. So what I tell people that's more accurate is I got beat up in practice quite a bit, but I didn't really get to play as much as I would have liked. But it was still fun to be at Cal during those years. And I love talking Cal sports with Kevin because I don't know anyone who's a more loyal fan than he is. One of his many great qualities. So we're here to talk this afternoon a little bit about the impeachment process. And the proceedings that are going on in particular today. So I just thought I would organize my 35 minutes worth of observations around several questions that have arisen in recent weeks and in recent months, actually, because even before this current impeachment, there was discussion of whether President Trump could be impeached a second time, even for things that happened before November 2020. So for example, Neil Katyal, who is a law professor at Georgetown, who was acting Solicitor General in the Obama administration, a friend, a wonderful guy, he had written some tweets to the effect that if a new Senate got elected in 2020, that President Trump could be retried for the very same things that he was tried for earlier in the first impeachment relating to interference with Ukraine and election matters. And I took the position then that while there's no prohibition on a president being impeached and tried twice, and certainly there's no double jeopardy protection that anyone has with regard to impeachment, that because the Senate, when it conducts an impeachment proceeding, is acting in a quasi-judicial body, that norms of res judicata should apply, so that you shouldn't be able to re-accuse and retry someone if the factual allegations are the same and the evidence is the same. So it's one thing if you uncover new evidence, that's sometimes a justification for relitigating something, even under normal res judicata principles. But if nothing has changed other than the identity of the jurors, in this case, the senators, I took the position that it wouldn't be appropriate to accuse and try President Trump again with regard to the Ukraine matter. Now, what we have before us today is a very different thing. Obviously, he is being tried and was impeached for matters that are totally new and totally different and outside the scope of the first impeachment. Nonetheless, the question of whether the Senate has the power to conduct this trial has been front and center in recent days for a different reason. It's not the generic concern about impeaching someone more than once. It's a concern about trying somebody after he's left office. So the narrow legal question is, can an impeachment trial occur for someone who's no longer holding federal office? And we saw that the vast majority of Republicans took the position early on that they believed the Senate did not have jurisdiction, that the Senate could not hold a trial for someone who'd left office. I think that's wrong. I would have said that that was wrong years ago. I have a little bit of distrust of people who take positions only after they know the identity of the affected actors. But as far as I can tell, I've always said to people that you can impeach and convict people after they've left office. And I said that in part because the Senate had done that. The Senate precedent matters to me. But before we turn to that precedent, let's just look at the text of the Constitution. Notice that the Senate has the sole power to try all impeachments. That's what the phrase says in Article 1. The Senate shall have the sole power to try all impeachments. Now, the word all there can't be an emphasis of the fact that the Senate is the only one to try impeachments, because that work is done by the word sole. The sole power to try impeachments would already get us to the point where no one other than the Senate can try impeachments. So the fact that we say all suggests that the Senate can try any impeachment that has taken place. And nobody denies that the impeachment of Donald Trump in January was valid because he was still in office then. The House impeached him or accused him. That's what impeachment is. Impeachment is the accusation. The trial is after the impeachment. It's an impeachment trial, but the impeachment is the act of accusation. And there was a valid impeachment. No one denies that. And the Senate has the power to try all impeachments. Perhaps even more textually important, I think, is the fact that judgment in cases of impeachment include not only removal from office, but also disqualification from being able to hold any office of honor, trust, or profit under the United States. So disqualification is an important consequence, at least potential consequence of conviction in an impeachment trial. And if somebody could evade impeachment or trial simply by leaving office, then the disqualification power that is given to the Senate would be virtually meaningless. There comes a point when the writing is always on the wall and you know you're going to lose. And if you could resign at that moment and leave office, you could prevent the Senate from ever disqualifying anyone for future office. And that wouldn't make sense, because why would they have given the Senate a power that could never be used? If we look at the founding history, we should observe, as Keith Whittington, a very well-regarded historian at Princeton, did in a Wall Street Journal op-ed a few weeks ago, that the state constitutions on which the US Constitution was in part patterned, they permitted impeachment of and trial of former officials. Indeed, some state constitutions allowed for impeachment and trial only of former officials, not sitting officials. The English history of impeachment that was imported to the United States also allowed for trials of former officials. And the Senate itself had already had at least one case in the latter part of the 19th century involving a cabinet member, William Belnap, who resigned right before the House was scheduled to consider his impeachment. The House nonetheless impeached him, saying he shouldn't be able to get off scot-free because he resigned. And the Senate debated whether it had the ability to try him, and decided by a 37-29 vote that they did have such a power. Now, it's true that he was acquitted, because he was acquitted by one vote. There wasn't quite the 2/3 supermajority needed to convict him. So it's not as great a Senate precedent as if he had been tried and convicted and disqualified. But again, a majority of the Senate, a supermajority of the Senate, found that his trial was within their jurisdiction. So the one really data point we have in terms of Senate precedent, and we should think not just in terms of judicial precedents, we should think of in terms of Senate precedent, that all cuts that way. Indeed, Senate precedents matter much more than judicial precedents in this realm. Why is that? Because it's likely that the federal courts, including the Supreme Court, would not wade into a question like this very heavily. Either this would be an absolute political question where the court felt it could not give any input, or at the very least, the court would say, we're going to defer to the Senate's own interpretation of its powers here. And as long as it's doing something that's minimally reasonable, then we're going to let it alone. Now, notice that's not what I'm not suggesting here, that there's no law to apply, that there are no legal norms. Gerald Ford is reputed to have said that high crimes and misdemeanors means whatever the House and Senate thinks it means. I don't think that's true. I think, as I'll say in a few moments, I think high crimes and misdemeanors has a legal content. I'm not saying that there's no there. What I'm saying is the Senate is the one that gets to decide this. We see that even from an important Supreme Court decision a few decades ago involving the impeachment trial of a federal judge, Walter Nixon. This was Nixon versus United States. It was not Richard Nixon, the president. It was Walter Nixon, the judge. And he complained that the way the Senate tried him was not constitutionally valid because they gave too much power to a particular committee to vet evidence and make recommendations to the Senate floor. And he said that's not really trial by the Senate as required by the Constitution, that's trial by committee. And the Supreme Court said, really, that's for the Senate to decide. They didn't quite say that they were completely divested of authority to review the matter, although there are parts of the opinion by Chief Justice Rehnquist that suggest that. I wouldn't say that's a pure political question, abstention, staying out altogether, because the court did go on to say that the Senate's approach to the meaning of the word try was a reasonable one, and for that, on that basis, the court wasn't going to second guess it. So I would characterize the attitude of the Supreme Court there as heavily deferential to the Senate, and so whatever the Senate decides here, that's going to be the final word. Now, to say that the Senate can hold this trial is not to say that they must. A lot of people back in 1998, when Bill Clinton was being impeached and tried, and a few years ago when Donald Trump was being impeached and tried the first time, and this time around, they seem to act as if somebody is arguably guilty of high crimes and misdemeanors that the House must impeach and the Senate must conduct a trial. And neither of those is true. The Constitution says the House has the sole power to impeach, and the Senate has the sole power to try cases of impeachment. But power is different than duty. And if the Senate had wanted to, it could have said, you know, he's out of office now. We don't need to hold this trial. We're not going to. The Senate itself has its own internal rules that seem to require some kind of a trial if and when the House sends an impeachment over. But those Senate rules are really of the Senate's own making. A majority of the Senate at any time could simply rescind those rules or alter them. So there's no obligation for the Senate to do this. Why then would the Senate want to do it? Well, it's what I mentioned earlier, the possibility of disqualification after conviction. Constitution is clear that if someone's convicted, and you need 2/3 of the Senate to convict, if someone's convicted in an impeachment trial, they're removed from office if they're still in office. And then the Senate may, but need not, doesn't have to disqualify them from future office holding. Some people and the Senate itself seem to believe that you only need a majority of senators to disqualify, even though you need 2/3 to convict. I'm not sure where that comes from. I think you probably need 2/3 to disqualify as well, because the Constitution talks about judgment in cases of impeachment extending no farther than removal and disqualification. But if the judgment for removal requires 2/3, it's not clear to me why the judgment for disqualification wouldn't require 2/3. It's true that, once you're convicted in a criminal trial, the judge doesn't need to use the same beyond a reasonable doubt standard to decide what to sentence you for. But increasingly, the Supreme Court has suggested that when there are facts that are relevant to the punishment that you're going to receive, that they have to be decided by a jury beyond a reasonable doubt under the same standards as guilt would be found. But that's the reason the Senate is doing this, the possibility of disqualification. Now, you're not going to get to disqualify unless you convict. And if there's not 2/3 to convict, then none of this really matters. But remember, when the House impeached and when the Senate was thinking about what to do, it wasn't yet clear that the Republicans weren't going to peel off in sufficient numbers to provide a conviction. Remember, early on, even Senate Majority Leader, now Minority Leader Mitch McConnell, said he wasn't sure about how he would vote in an impeachment trial. He was sending signals that suggested you could maybe get to 67 senators. You could imagine 17 Republicans joining the 50 Democrats to get to a conviction. Now it seems very unlikely that will happen, because you had 45 Republican senators clearly signal by their vote that they didn't think that the Senate had power to do this, that they're not going to actually disqualify Trump, that the political costs are too high to pay. Which suggests that if the Senate and the Democrats in the Senate had wanted to, they could have eschewed a trial and instead gone a different route that might have made it harder for Republican senators to avoid weighing in on the gravity of former President Trump's misconduct. Censure would have been an option to consider. The Democrats could have said, okay, we're not going to try him because he's gone and we don't want to mess with that, but we're going to propose that he be censured. I don't think a censure motion would have violated a bill of attainder provision or any other aspect of the Constitution. And then Republicans would have to weigh in on why they're not willing to censure this misbehavior by President Trump. It would have been a little harder for them to avoid the merits, if you will. Right now, a lot of Republicans will say, well, we don't have jurisdiction, so I don't think we should reach the merits of whether what he did is high crime or misdemeanor or not. On that point, I will say a couple of small things. Even those senators who don't think that the Senate has jurisdiction should be put to the task of weighing in on the merits, because they lost on the jurisdictional matter. There are plenty of cases where a member of the Supreme Court thinks the court doesn't have jurisdiction over a case, but when a majority of colleagues disagree, they feel empowered, indeed sometimes obligated, to weigh in on the merits because they've lost on the jurisdictional point. Just last December, Justice Gorsuch did that in a case. He said, I don't think we have jurisdiction, but a majority does, so I'm gonna rule on the merits. I'm gonna vote on the merits. Republican senators should be asked to explain why they're not gonna do the same thing, even if they believe the Senate doesn't have the power here, having lost on that question. Indeed, in the Belnap trial, notice that 29 senators rejected the notion that the Senate had jurisdiction to try Belnap after he left office. And yet, seemingly, many of those senators voted to acquit on the merits, suggesting that once there was jurisdiction, they were free to weigh in on whether or not he should be convicted. Again, I think, you know, there could be some pressure brought to bear on Republicans to weigh in on the conduct itself. Now let's talk about that conduct and whether it satisfies the high crimes and misdemeanors threshold. I personally have been a little disappointed both in the first impeachment and the second impeachment in the framing of some of the charges. Remember, in the first impeachment, there were two charges: abuse of power, which I thought was properly framed, but obstruction of Congress, which I thought was misleading. This time, one of the sole charge is incitement. The problem that occurs when you use words like obstruction and incitement is you tap into a body of legal definitions and restrictions, statutory definitions and restrictions that have very little relevance in the impeachment setting. Impeachment is not a legal, criminal, or civil proceeding. It's a political mechanism to remove people who are unfit for office and prevent them from serving again. So I don't care whether President Trump has a First Amendment right to say the things that he did. He clearly does. Even January 6th, even that rally, even the stuff that he said, that stuff was protected under the First Amendment, under Brandenburg and incitement doctrine. So he has a First Amendment right to say it, but you don't have a First Amendment right to ever hold federal office. Impeachment is not about punishment in the civil or criminal sense. There's a whole separate process for that. And indeed, the Constitution says people who are impeached are subject to that civil and criminal process thereafter. It's totally separate. But when we talk about obstruction and incitement, we get people thinking in these legalistic ways that I think are unhelpful. It doesn't matter whether the president intended that the mob go down and break into Congress, the way it would matter if we were trying to criminally convict him for incitement. Under Brandenburg, to be an inciter, you have to intend that your audience go do something illegal. But impeachment isn't about whether you intend to do anything bad, although obviously intent can be part of why you're unfit for office. But there's lots of impeachable grounds that don't involve intent. You could be senile. You could be incompetent. You could be, substance addicted. All of those are bases for impeaching and removing and disqualifying somebody that have nothing to do with whether they intended to do something wrong. So from my point of view, if we focus on President Trump's inherent unfitness to have been in high office and to be in high office later, to me, it was the disrespect of democracy, the denigration of democracy, the lies about facts, the lies about the election results, the lies about the voting system, about votes being switched, about dumping of votes, etc. All of those things are impeachable whether or not the riots of January 6th ever occurred. Now, I'm not saying that January 6th is irrelevant, because January 6th kind of shows why that course of conduct for the previous months, and I would take it back to the debates even before the election, someone refusing to acknowledge that we have an obligation to permit a peaceful transfer of power if that's what the election officials certify, that's impeachable conduct. That should disqualify you from office right there. So I'm not saying that January 6th is unhelpful, and it's certainly rhetorically and emotively powerful, but I would say all the stuff he did before that would have been high crime and misdemeanor, even if people had stormed the Capitol. Why? Because he's eroding democracy in a way that nobody who is fit for high office should ever do. And that's true, by the way, even if he believed his own lies. One of my favorite characters in TV, George Costanza on Seinfeld, once told Jerry Seinfeld, he says, "Remember, it's not a lie if you believe it." I think President Trump might believe some of this insanity. He might believe that the election was stolen from him. When he called the Georgia election officials, and now that's under criminal review, although it's hard for me to imagine you could make a case about that, and he asked them to find votes. In context, what he was saying is, I think I won by hundreds of thousands. Can't you credit me with some of the ones that I got? I think that's what he meant by find. But none of that is irrelevant. If he actually believes that he won all these swing states, that's even more disqualifying than if he is lying about it for political gain. It's disqualifying either way. And that's what high crimes and misdemeanors is all about. It's about fitness, and fitness goes not just to honesty, although again, I think honesty can certainly bear on unfitness. See Richard Nixon, see Bill Clinton, but it doesn't have to be dishonest to render you unfit. And that's why I would really focus on the corpus and less on these technicalities of what constitutes incitement or obstruction. Final few things I'll say, and then let's open it up so we can have more of a discussion. There was a lot of question about who should preside over this second impeachment trial. The Constitution is pretty clear that when a sitting president is being tried, the Chief Justice shall preside. That's why the first time around, John Roberts presided over the impeachment trial of Donald Trump. And it's easy to see why that's so, because in the absence of that provision, the ordinary president of the Senate is the vice president, and we can imagine why a vice president should not preside over a sitting president's impeachment. Why? Because if the president gets convicted, she's automatically removed, and the vice president would then become president. That's a pretty big conflict of interest. That you know, you're presiding over a proceeding, the result of which could vault you into the White House. But the Constitution is silent about former presidents and when they are tried. I think it's fair to read the provision involving the Chief Justice as not necessarily applying that he mustn't. It's not clear that he must be the one to preside over this, because it does say the president, and Donald Trump is no longer president. He's a former president, even though we sometimes talk about former presidents as we still say President Clinton or President Bush, but strictly speaking, they're not president. They're former president. But that doesn't mean that Chief Justice could not preside if he were invited and he were willing to do it. Shall might mean must, but the fact that he doesn't have to preside doesn't mean that he couldn't preside. And optically and politically, maybe it would have been good if he did preside. A lot of people said, well, Kamala Harris, Vice President Harris, is conflicted because she's been such a critic of President Trump. That can't be a basis for a real conflict of interest. Ben Sasse has been critical of President Trump. Republicans and Democrats in the Senate have often been. So that would conflict too many jurors as well as the presider out. Some people said, well, she was the beneficiary of the very election that is in question. The heart of Trump's defense is that this was a rigged election. And so she has a conflict because she was the beneficiary of the rigged election. Well, again, a third of the Senate that got elected in November 2020 is the beneficiary of the rigged election. And the party, it was a beneficiary of the rigged election. So I don't think any of these was real legal conflicts of interest that would require anybody to step down. I think Vice President Harris certainly can decide that she doesn't want to be presider over this. I think she could have presided if she wanted to. She can give it to the President Pro Tem of the Senate, Pat Leahy, instead, if she wants to. But if the reason that she's giving it to Leahy is to avoid optics and perceptions of bias, then maybe the argument would have been, let's go all 9 yards and give it to a justice of the Supreme Court. That would be kind of most beneficial optically and deflect criticisms about potential bias to an even greater extent. And remember too that this is a very narrow presiding power. It's not like a regular court where the judge has ultimate authority to do a lot of things like ruling on admissibility of evidence, et cetera. The Senate rules allow a majority of the Senate to override the presider in impeachment trials in many important matters. Now, I'm not saying that the presider doesn't have any authority, But ultimately, this is more a matter of perception than power. And if that's the case, then I think it would have been perfectly appropriate to ask John Roberts to do it. Now, maybe he wouldn't have wanted to. I totally understand that as well. But I don't think he was disempowered from it simply by virtue of the fact that the Constitution doesn't require that the Chief Justice be the one. So, Kelly, it's a little after 12:30, so why don't we open it up for some questions if you have any, and I'll use those as springboard to talk about other things as well as they come up.
Great. And we do have questions that have already started to come in, and I will start with a question from Joel, who writes, you stated that an official could be impeached when they are unfit to due to senility or other physical unfitness. What is the historical or legal basis for permitting that under the high crime and misdemeanors language of the Constitution?
So most of the impeachments that have taken place since the founding have involved federal judges and some cabinet officials, but federal judges. But federal judges have been impeached for incapacity due to mental inability. And it makes sense. I mean, how on earth, a judge, it has life tenure and they can't do their job. They're supposed to continue to hear cases. They're supposed to continue to decide the fate of defendants. Look, the Constitution is at base relatively sensible. And the impeachment provision reflects that common sense instinct that there has to be a way to remove people who simply can't do the job. So too with the president. If a president, remember, it wasn't until very recently in the 1960s that we had a constitutional amendment that allowed for filling a vice presidential vacancy. So you could have, a president who was in a coma or who died and then was replaced, and there's no one in the vice president's office. There has to be a way for the leaders of the executive branch to be able to continue to function, and so there's no historical or other suggestion that you couldn't remove someone simply because they're not doing the job. Imagine a president, for example, who simply flew off to Europe and was ignoring doing the job. They wouldn't attend meetings, they wouldn't attend briefings, they wouldn't respond to legislation. They just checked out. Before the 25th Amendment, there was no mechanism for the cabinet to temporarily remove them. They're not dead. What are you going to do? Live with that for 4 years?
Okay. Question from Professor Martha West, who says, assuming the Senate does not convict, is there a provision in the US Code to prevent someone from running for office again? And if so, who would file that action?
Hi, Marty. Good to see you. I saw your picture earlier. Nice to see you doing well. I don't know of anything in the US Code that would prohibit somebody from running for president. Apart from the implementation of Section 3 of the 14th Amendment, the 14th Amendment, Section 3, which is rarely discussed, disqualifies people who are guilty of insurrection from serving in office. But my understanding of that provision and the implementation of it by Congress is that would require some kind of a judicial proceeding wherein someone is found to have been guilty of insurrection. So it's not just up to a majority of Congress, as some people have posited in op-eds, and it's certainly not just up to anybody. If a state wants to allow somebody to be considered in that state for the electors of that state to support in the Electoral College, short of a trial that finds someone guilty of insurrection under the 14th Amendment, I don't know of anything that would. I think the two ways that the federal government can disqualify someone from running for president are impeachment, conviction, and disqualification. That's one. and conviction of insurrection under the statute that implements the 14th Amendment.
We have a question from Stephen who says, can the Congress compel a competency exam on a president?
I think that would probably be a separation of powers problem. It's not clear to me what a competency examination would consist of. But I think especially after you have an amendment adopted in the 1960s to deal explicitly with the possibility of mental incapacity of a president, that allows the vice president or the cabinet to trigger a consideration of whether the president needs to be relieved of powers for a period of time for Congress then to be able to assess whether to reinstate those powers. I think most people would read that as the exclusive route for dealing with these kinds of problems. Now, that brings up a bigger issue, and that is that the Constitution and its design really assumes a world in which people are not going to be quite as tribal and partisan as they are now. That is to say, whether we're talking about the impeachment device, whether we're talking about the 25th Amendment, whether we're talking about any of the other things that provide for kind of very unusual situations that might arise, the Constitution's framers did not expect people to cling to a party chieftain as much as the Republicans are clinging to Donald Trump today. I mean, at some point, nothing works if people aren't willing to confront reality and confront facts and rise above fear and personal loyalty. And that would be true even if Congress could compel an examination. Well, so what? You have the examination, then what happens? You've got the president who responds to the medical report that is issued saying he's got some mental issues, saying it's fake. It doesn't, he'll produce his own psychiatrist who will say the president is totally fit. And then we'll have, 37% of the country believe him and 50% of the country disbelieve him. And we're in where we are now. I mean, the problems we have are deeper than the Constitution. They relate to democracy in a pre-constitutional way. The inability for people to make decisions based on factual evidence, a media that is not responsible. These are the deeper problems that we have that we need to start confronting. And I don't know what the solution to those are. I mean, maybe libel actions like the ones brought against Rudy Giuliani and Fox News, maybe that's part of the answer. I see Alan and Beth Brownstein, and Alan and I talked a few weeks ago about maybe writing a piece about how libel law, which has to be very careful not to deter political speech, may need to rein in political factual falsehoods, factual lies. It's one thing to allow people to make grandiose claims that aren't factual, but when people lie about facts, even in the political realm, maybe there's room for the libel law to help rein that in. Maybe some of the answer is dealing with the effect that social media platforms have and algorithms have on making people ever more siloed and ever more extreme. I don't know what the answers really are here, but they go beyond plain constitutional thinkers like me. It really requires a more fundamental reconsideration of the way society is operating.
Great. We have a question from Camille who says, you mentioned censure as a possible approach. Is it still an option if impeachment fails, or would the impeachment preclude censure?
You haven't given it a lot of thought, but I don't see why it would be off the table necessarily. I think, again, as I intimated earlier, to me, the big constraint on censure is whether it constitutes a person-specific punishment in a way that violates the prohibition on bills of attainder. So one thing that the Constitution tries to do is make sure that if you're going to be punished, you get to go through a court of law. I said earlier, impeachment's not about punishment, it's about removal and disqualification from office. And you don't have an entitlement to hold office. You do have an entitlement to be free of punishment, absent some kind of legitimate due process. But I don't, insofar as the censure wouldn't really have any tangible consequences attached to it, it wouldn't impose a fine. It wouldn't. It would not require the forfeiture of liberty in any way. It's not remotely clear to me why it would bump up against a bill of attainder. I said that with regard to Bill Clinton in the 90s. I thought that a censure was a reasonable thing to consider back then, and I think it is today. Now, the question Camille raises, I guess, is, well, does that change after an impeachment acquittal? And I should note in this regard that, remember, to convict someone in the Senate, you need 2/3. But interestingly, when you don't get 2/3, even if you get a majority to convict, the historical practice is to say that the person has been acquitted in the Senate trial. So Bill Clinton was acquitted in the Senate trial. Andrew Johnson was acquitted in the Senate trial, even though both of them had a majority of people vote against them. And so ordinarily, we would say if there's not, a unanimous jury either way, or in this case, 2/3 of the Senate either way, we would just say it's kind of a hung jury. It's not an acquittal. But we don't say that. So President Trump will likely be acquitted in this trial, just as he was acquitted in the earlier trial. So then the question is, okay, if he was acquitted, does that bar censure? And I'm not sure it should, both because censure doesn't have any legal consequences anyway. It's more of a political statement. And I want to put Republicans to the task of weighing in on this political statement. But also, because disqualification is not on the table, it's a different standard. You may very well think the president should be censured, and yet not think he should be convicted in an impeachment trial. The analogy I might draw is between criminal and civil proceedings for purposes of res judicata. You can be acquitted in a criminal trial, but nonetheless subject to civil proceedings, like O.J. Simpson was. O.J. Simpson was acquitted, but he was then subject to civil proceedings, because beyond a reasonable doubt is a different standard than preponderance of evidence, and unanimity is a different standard than majority or supermajority, as is true in some civil settings. So I don't see why it's not possible. I did read an article a few weeks ago that suggested, though, that for whatever reason, the Democratic senators aren't interested in this. Now, I understand why they weren't interested in censure early on after the House impeached, because, as I mentioned, there was a possibility that you could have gotten Mitch McConnell and 16 other Republicans to join and actually get a conviction. And if you can go for that, why not go for that if you're a Democrat? So I understand why they didn't want to really pursue censure then. And maybe they'll be willing to pursue it after this vote is over, but they don't want to make it easy for the Republicans to vote to acquit by putting that on the table too soon. So I don't know for sure whether it is a dead letter, but as of now, the Dems don't seem to want to talk about it. Maybe it's just a matter of timing, but I think it's certainly worth exploring after the acquittal, if the acquittal comes as people expect.
We have another question about a scenario if former President Trump is acquitted. The question is, if there is an acquittal and he is not convicted of a felony, could his candidacy, if he ran for president again, be challenged by qualified voters in the state elections?
I'm not sure on what basis he would be subject to challenge. So remember, it's up to each state to decide who can be placed on the ballot. I think states can have wide leeway to decide that people don't belong on their ballots. So I've written, for example, that states can require candidates to disclose their tax returns lest they are not listed as a candidate on the state ballot. There's some people who think the Supreme Court would find that impermissible because a state would be seeking to add additional qualifications to the office of president beyond simply being 35 years of age and a natural born citizen. I don't think that's true at all. But even if a state has the latitude to do that, I don't know that you could force the state legislature to do it via any kind of a judicial action. I think it's really going to be up to the state legislature. Now, you could in states that have direct democracy, I suppose you could have an initiative drive to disqualify people from the ballot. And again, I personally think Article 2's broad powers given to the states. It says each state shall appoint a group of electors in whatever manner, in such manner as the legislature thereof may direct. And legislature includes the people acting via direct democracy under Articles 1 and Article 2. So I think a state can decide for itself who it wants to, but a state can't decide for other states. So let's say California doesn't allow Donald Trump on the ballot, but other states do, and he gets a majority of electors from those other states. I don't think there's anything you can do to go to court to block that in any particular place.
Mm-hmm. Okay. A question from Susan. Is there enough evidence for a criminal case against Trump? And she uses an example of Charles Manson, who incited murders but did not kill anyone.
So I'm not a criminal law expert, and I'm not an election law statutory expert. So there's lots of things President Trump did while in office that were quite objectionable, shall I say, from my point of view. But if we're talking about incitement as a crime, I do not believe, as I mentioned earlier, that the First Amendment would permit President Trump to be guilty, to be found guilty of incitement in a criminal sense for anything that he said. Now, he certainly uttered falsehoods for many months, but they weren't uttered in the setting of imminent lawless action. So he might be suable in libel law for a lot of the falsehoods, a lot of the slanders that he made towards Dominion voting systems, the way Rudy Giuliani is being sued for libel, et cetera. So he may be civilly liable for that. The only setting in which incitement would come into play was his January 6th rally that preceded the riots. But there too, I just don't think anything he said would satisfy the Brandenburg test of proving that he intended his audience to go break the law and do so imminently. I mean, let's be honest. The words he used, you got to fight like heck. If you don't fight, you're not going to have any more of a democracy. Even Rudy Giuliani's, idiotic trial by combat, all this stuff, that is not over the top in American political rhetorical history. I could find you many Democrats in the civil rights movement and in other eras who used very vivid imagery to convey the conviction they had about how energetic people have to be to work towards justice. And so I find it hard to believe he could be found guilty of incitement for that. Now, what about election tampering? There too, again, I'm not an expert, but I think it's a hard sell. Headlines in the past few days say that Georgia officials are investigating him criminally for his phone call to the Georgia elections folks. But even though the use of the word fined was really, I think, inartful, in context, I would have trouble finding beyond a reasonable doubt that by fined, he meant manufacture, as opposed to credit votes that I actually got because I won by hundreds of thousands. Again, in the criminal setting, election tampering might require that he actually believe that he's doing something corrupt. And I'm not sure that he's just not deluding himself. I think he may believe that he won Georgia and that he won Pennsylvania and that he won Arizona. And getting jurors to unanimously find beyond a reasonable doubt that he was knowingly lying as opposed to speaking something that has no basis in objective reality, that's a hard call. The final point I'll make about this is I think we should be careful before we try to use the criminal sanction to punish people for aggressive rallies and for trying to fight for their election outcomes if they think they've been robbed. That's a slippery slope that I don't want to move down too quickly. That's why I think impeachment is the right device to remove and disqualify. But I would rather beef up impeachment and expand its potential scope than to use the criminal sanction too aggressively. That's where you get the lock her up stuff. And that I found really troubling. And as much as I found the last 4 years hard personally to endure, I'm not, in my calmer moments, I'm not sure I want to lock him up any more than I thought that Hillary Clinton should be locked up.
Talking about the process of impeachment, Dean Johnson sent a comment along and says, does your analysis of impeachments in US history suggest the need for any constitutional amendments to improve the impeachment process?
It's a good question, Kevin. I haven't thought about that in any detail. I would certainly be open to tinkering with the impeachment provisions. At a minimum, providing some clarity. Some people, for example, don't think that you can disqualify someone from presidential office. They think you can disqualify them only from appointed office, federal judgeships or cabinet seats. I don't agree with that, but maybe that would be worth clarifying. Would be worth clarifying whether you need 2/3 vote to disqualify, just as you need 2/3 vote to convict and remove. So I think some technical cleanups could be valuable. Whether they're maybe this is something that could actually get a supermajority of Congress and wouldn't be that contentious in the states if it were done kind of well after this proceeding ended and if it were really procedural in nature. I will point out that if you take a look back at the history of amendments, we've only had 27 amendments in these almost 2.5 centuries or 2.25 centuries. And of those 27, the first 10 and the 27th Amendment were all part of the package of the original Bill of Rights. They were part of the deal by which the original Constitution got up and going. So they weren't really even amendments. Those were part of the original deal. So we've really amended the Constitution 16 times in these 2.25 centuries. Of those 16, 2 of them cancel each other out, more or less. 18th Amendment prohibition, 21st Amendment repealing the 18th. It does a little more than repeal the 18th, but for present purposes, they're kind of nullifying. And then you had 3 amendments that came after the Civil War that were, rather extraordinary in terms of the procedure they used. I think they were perfectly lawful, but I don't want to have to fight a civil war to amend the Constitution every time. So we're talking about, like a dozen amendments left that are adopted during what we call an ordinary process. And if you look at them, almost all of them deal with election procedures and cleaning up the process of elections. So whether it's expanding the franchise to Black men or to women or to young people or to poor people, the way the 15th, 19th, 24th, and 26th Amendments do, whether it's giving presidential voting rights to the District of Columbia, giving them 3 electors, whether it's limiting presidents to 2 elected terms, whether it's providing for vice presidential succession when there's a vacancy there, or temporary incapacity of the vice president. All of these are of a piece of trying to kind of clean up the elections code, if you will, and make it ever more kind of democratic and ever more sensible. So what you're suggesting is fully in keeping with the tradition of amendments. And so I would be open to that. I haven't seen people propose specific ones, and I don't have one in mind. But I think it would be a good area for people to look at. And even if it were narrow, and it would have to be narrow to get consensus, if you have to avoid some of the contentious things, it would be worth exploring. One final point I'll make is, I think changes to the Constitution that are likely to be viewed as helping one party or the other are really unlikely to succeed and not worth pursuing. You know, as you know, Kevin, I've done a lot of work on electoral college reform and the National Popular Vote Interstate Compact. And one of the things that's disappointed me is that the idea of moving towards a direct popular election has come to be associated with helping Democrats and hurting Republicans, because Republicans don't seem to be winning popular votes these days. I don't think that's necessarily true. You know, a lot of people thought George Bush would win the popular vote and lose the electoral college in 2000. In 2004, John Kerry almost won the presidency, even though he lost the popular vote to W, et cetera. So one of the things I've suggested is, if you want to move towards a national popular vote, maybe you delay implementation of that for 10, 12 years, so that by then no one will know what the partisan implications of it are. So too with impeachment reform. I think if you wanted to have any reforms in there that were arguably partisan, one response would be, okay, let's delay implementation for several presidential cycles, so we don't know which president we'd be helping or hurting. So I might add that to the things that the people who might be thinking along those lines would consider.
Great. This will be our final question, and I thank everyone who's sent in your thoughtful comments, and apologize for not being able to get to all of them. But we have kind of a technical question here from Donald, who says, what about hearsay evidence in the trial? There appears to be Senate rules applying federal rules of evidence on hearsay, but it isn't clear that it's being applied.
So I'm not an evidence expert. I'll confess to you, actually, I never even took evidence in law school because no one was really teaching it during those years I was at Yale that was kind of known for the field. And I don't really know much about the Senate rule that you're talking about. So I can't really opine on whether the Senate is complying with its rules or not. Those rules, of course, could be changed by the Senate itself, although it would really look bad to change procedural rules on the fly during the course of an actual proceeding. But I will say that the Senate might use the word hearsay in a different way than the federal rules do. If they incorporate by reference the federal rules of evidence, then maybe they should live up to that. But I know enough about evidence too that a lot of the federal rules are not self-implementing. And for example, prejudicial value versus probative value, and which outweighs the other. Those are really judgment calls. So too, just studying for the bar, I remember the exceptions to the hearsay rule being flexible enough that reasonable people can disagree on whether the excited utterance or statement against self-interest exception applies. So before I concluded that the Senate was really blowing off its own commitment to follow the federal rules of evidence, I would acknowledge, I would be careful to make sure that they're just not construing what hearsay is, or the applicability of the hearsay exception maybe differently than someone who else is looking at it.
Thank you.
Well, thank you, Dean Amar, and thank you all for being here. I think we're all in a better position now to have a full understanding of what's been going on in Washington, D.C. And I think Dean Amar for that. Take care.
Thank you all for having me. It was great to see you all. Take care.